This afternoon, we are honored to have an esteemed panel of experts from across the region who are joining us from the different jurisdictions to come and share with us their insights on the different developments of family law practice from within their jurisdictions. And to start us off, we do have Dr. Baraka Kanyabuya. Dr. Baraka is a lecturer and head of private law department at the University of Dar es Salaam. A very good afternoon, Doctor. We are profoundly honored and exceedingly humbled to host you. And at this juncture, allow me to invite you to start off the discussion by sharing with us the practice and procedure of divorce and dissolution in Tanzania, while sharing with us the new and emerging trends in this area of practice. Karibu sana, Daktari.
Thank you very much. Very good afternoon to everyone.
Good afternoon.
Let me start by making a small clarification. I'm no longer serving as the head of Department of Private Law. I think my information have not been updated for quite some time. I used to be the head of department from, I think, 2015 up to 2019. So currently we have another head of department. Having said so, my topic is to highlight on the practice and the procedure of divorce and the dissolution in Tanzania, and highlighting the new development and the emerging issues. My names are Baraka Francisco Kanyabuhinya. I teach law, but I'm also a registered advocate. So in the highlight, or in the, at the outset, let me start by saying that you see, in Tanzania, we have two parts of the union, and legal matters, non-union matters. When you talk of mainland Tanzania, we have our own legal system. And when it comes to marriage law, we have our, again, our own legislation. And in Zanzibar, again, they have their own legal system and they have their own divorce law. But understanding that the population in Zanzibar is composed of almost 95% who are Muslims. They follow what we call Islamic law, and they have Islamic court in the name of Qadhi courts. So basically, what I'm going to focus on is on the divorce law and the dissolution as in Tanzania mainland, and I shall mainly pay much attention to the Law of Marriage Act of 1971, which is which is applicable in mainland Tanzania. Now, like I said in the introduction, when you talk of divorce, you are talking for legal dissolution or termination of marriage. And as you can agree with me, marriage can be dissolved. Marriage can come to an end by two ways, either by way of divorce or by a decree of nullity. Although when it comes to nullity, we may technically say in nullity, you are not dissolving any marriage because technically there's nothing as marriage when you are talking of an invalid marriage. So the law applicable, like I said, is the Law of Marriage Act. And like I said, I will just highlight on the key provisions when it comes to the to divorce. So it is cited as the Law of Marriage Act, Cap 29 of revised editions of 2019. And as in many common law jurisdictions, there is just one ground of divorce, and that is to prove that the marriage is broken beyond repair, or sometimes they say where a marriage is broken down irreparably, and in some readings they call it a marriage broken down irretrievably. Now, some authors and some scholars do confuse when they are asked about talking the grounds of divorce, and they normally cite Section 107 of the Law of Marriage Act, which actually takes you through what we call matrimonial offenses. So to some scholars, they normally cite Section 107, which talks about some matrimonial faults, But I think that citing section 107, which talks about matrimonial offenses, and using the same as proof of grounds for divorce, I think is a misnomer. Normally, the ground for divorce is under Section 99 of the Law of Marriage Act, and there is one ground for divorce, which is to prove that the marriage is broken down irreparably. Now, Section 107 of the Law of Marriage Act basically gives you some evidence which you may prove that a marriage is broken down irreparably. Again, proving one of the grounds under Section 107 may not entitle you to divorce, because again, it is in the discretion of the court to decide whether, considering the circumstances, such conduct can render a marriage broken down irreparably. So under Section 107, what is provided for under Section 107 is evidence of marriage breakdown, and not evidence to show that the marriage is broken down irreparably. Now, in the list, there are misconduct such as adultery, cruelty, willful neglect, or sometimes desertion. So those are not grounds for divorce, like I said. Those are just grounds to show that marriage is broken down. So the court will have to consider a number of factors, including the frequency, maybe, of occurrence of these events before it can come to the conclusion that a marriage is broken down irreparably. And going through case laws, there's a number of cases which actually shows some sort of confusion between our judiciary when it comes to interpreting on how marriage is broken down irreparably. But the court will have to consider a number of factors and how events are factored to the married couples before the court can reach the conclusion that the marriage is broken down irreparably. And there is a wide jurisprudence on how to establish this ground for divorce. So, like I said, apart from desertion and neglect, another ground to prove breakdown of marriage could be separation for at least 3 years, mental illness of the respondent. Of course, there should be 2 doctors, and one should be qualified in psychiatry, and he must certify that there's no way you can cure. The respondent can be cured or can recover. But the other factor to prove breakdown of marriage is the change of religion by the respondent, where the parties followed the same faith at the time of marriage. So I think it is very important to understand what are the criteria that the court will normally take into consideration before coming to the conclusion whether the marriage is broken down irreparably. So the court will normally consider relevant evidence regarding the conduct and the circumstances of the parties. I remember, for instance, in one case which I was reading, the husband engaged into marital violence, and he stripped naked his wife in front of the father-in-law. And that single event was considered to be very factual, considering, being naked before the father-in-law. So a single event may suffice to amount to irretrievable breakdown of marriage. However, in some circumstances, a single misconduct, again, may not be sufficient. For instance, we understand that African society are promiscuous. So, for instance, a single conduct of adultery by the husband, in most cases, if you do the studies, do not qualify to make the marriage to amount to an irretrievable breakdown of marriage. However, on the other side, if it is the same is committed by the wife, then that may be sufficient to prove that the marriage is irretrievable breakdown. So that it depends on cases and facts of cases. There are some factors, like I have noted and indicated, to be taken into consideration, like, for instance, the custom of the community to which the parties belong. So the other important feature that we have to notice that in Tanzania, there is no question of divorce by consent. So parties, no matter how much difficulties they are going through, may not agree to get divorced. So there's no question of divorce by consent, although there is a debate on why would you force the parties to live together if originally they contracted a marriage by an agreement. The question is, why can't you allow them to dissolve the same kind of agreement on their own wish? So I have to highlight that. And actually, there is one case where the court decided that it is possible for parties to get divorced by consent. And I think on appeal, that kind of principle was disallowed. So there's no question of getting divorced by consent of the parties. Of course, you must also understand that in Tanzania, we have a mix of people who are following, various religious beliefs. We have Muslims, we have Christians, we have the non-believers. And because of that, when it comes to Islamic communities, the issuance of talaq is not recognized as an automatic dissolution of marriage. So there is a principle in Tanzania that divorce can only be granted by the competent court of law. It's not by parties. So for Muslim communities, for instance, issuance of 3 talaqs is not a final and conclusive proof that a divorce is granted. However, of course, there is a provision which says for Muslims, if they've gone through a marriage reconciliation board and the board has failed to reconcile the parties, and subsequently the talaq is issued, then the court will just have to note about the circumstance and they issue the divorce. So it cannot go further and question about the facts of the case. It will just note and it will immediately issue the decree of divorce. Now, in terms of procedure, like I highlighted, first of all, there is a requirement that before you can petition for marriage, for divorce, then you have to prove that parties have been married for at least 2 years. Unless there is an exception, if there are extra difficult circumstances, then that's when that condition can be waived. So that is one of the conditions, that you must have at least married for at least 2 years. But the other requirement is that before you can petition for divorce, you must submit the dispute before the marriage conciliation board, and the conciliation board must try to settle the matter. And if it fails, then it must certify to that effect. And in your petition for divorce, you must attach that certificate from the marriage conciliation board. That a certificate from the marriage conciliation board, then the suit will be dismissed on the ground that it is immature. I have cited the provisions for reference of the matter to the marriage conciliation board. That is under section 102 up to section 104 of the Law of Marriage Act. And the rationale behind, going through the marriage conciliation board, I have said, you see, marriage is taken to be a serious institution, and therefore there should be some efforts to rescue the same before moving for divorce. In fact, they say divorce should come as a last resort kind of option. So there should be some effort to rescue the marriage. Talking of marriage conciliation boards, I think in this area, again, there's some confusion on what is the proper marriage conciliation board. What the requirement is that any community body or religious body, if it is registered by the Minister for Legal Affairs, then it can be recognized as a marriage conciliation board. So it includes various religious boards and some community boards. The only requirement is that it should be registered by the Minister of Legal Affairs. And in accordance with recent amendments, it also recognizes what we call the ward tribunals. The ward tribunals established at the level of the ward to serve as marriage conciliation boards. Like I said, you cannot file for divorce unless the marriage has lasted for 2 years. I think that is a repetition. I said also you have to refer the matter to the marriage conciliation board unless you can show, unless the exception is that if you can show that parties are undergoing through some unbearable kind of difficulties, or if the respondent is, for instance, suffering from incurable mental illness or imprisoned for life for a term of at least 5 years, or if he's residing out of Tanzania, then those are the grounds which can waive the requirement to go through the marriage conciliation board. And therefore, like I said, of course, the other exception is to make the reference to the board impracticable, like if the respondent, for instance, lives in a foreign country. So this is the procedure of filing for divorce. The document that you use is called a petition for divorce. This is just like ordinary pleadings. Instead of calling it a plaint in a civil suit, it is called a petition. And this is under Section 99, and it also provides what you should include in that petition, like the particulars of marriage between the parties, their names, sex, children, if any, particulars giving the court's jurisdiction. I believe most of us here are lawyers, so basically it is structured.
Dr. Baraka, can you hear me? You are frozen.
At the way we normally structure a plaint, what factors prove that the marriage? Yes. Breakdown somewhere. Hello?
Yes, doctor, we had lost you, but you can proceed now.
Okay. Can I proceed? So I was just explaining about the contents of a petition for divorce. Essentially, I said it looks like a plaint, save that the name should be petition. So if you name it a plaint, it may be dismissed. It should be called a petition. And of course, you must
Dr. Baraka, I think we have lost you there. Dr. Baraka, if you can hear me, I think we've lost you.
Support what you have alleged in the petition, the contents of.
Okay, ladies and gentlemen, we seem to have lost Dr. Baraka. He must have experienced a drop call, but he was taking us through the very interesting sphere of family law practice in Tanzania. And what really stood out for me is the Marriage Reconciliation Board. But that said, allow me now to officially introduce our moderator for the session, Mr. Samuel Ejoko Onyu. Mr. Samuel Ejoko is a practicing advocate of the Courts of Judicature of Uganda. He's a lecturer at the Law Development Center, and he has over 7 years experience of instructing and mentoring students in a number of universities across Uganda and the region. He's worked for the DPP of the Republic of Uganda as a senior state attorney with over 8 years experience, and I am happy to mention that I went through his very able hands at the Law Development Center. Mr. Ejoku, I'll hand over to you now to introduce the next speaker, and then you take it on from here. Thank you so much.
All right, thank you.
Are
Thank you,
you able to
Gabriel.
turn on your video?
Sorry for the, I hope I'm able to. Let me try. So let me
Okay,
try to
perfect.
turn on. Can
Yes, we
you,
can now see you.
I hope that's the manual. Okay, thank you. Sorry about the mishap. We've had
Thank
a
you
bit
again.
of connectivity issues today. And I hope that you will be able to take on whenever I face any challenges. Thank you, Gabriel, and our presenters. I wish to thank Dr. Baraka for having come in quickly just as the network was disturbing us. Right now, I just wish to just make a few remarks to just mention that I hope we have been following the discussion because I wasn't able to make any and say anything at the beginning. I believe that it has been enriching right at the beginning. Thank you, Dr. Baraka. Asante sana. And I believe we all agree that at this point, marriage is such an important element within our society that is able to keep relations going in a meaningful way. And the foundation for it, as has always been said, is love. Now what we are talking about is that it appears to be something that is a building block of society, but then some scholars have stated that whereas you have the right to marry founded on love, there seems to be also the right to unlove. I think this is what we are discussing now, and our panelists are going down this path, trying to let us understand what the legal understanding of the unloving or dissolution or divorce within the region is. So we have looked at what it is within the Tanzanian context, and I believe that we are preparing some questions. I will request that we go through with the presentations, and then we reserve the questions at the end. I don't know, Gabriel, if that is fine with you, because it will take a lot of time if we break the segments. So that being the case, I believe that we should be going now to Kenya. Madam Juliet Komagom, I hope that you are with us. You're in the background, just waiting to come and speak to us about what it is in Kenya, what the practice is in the area, this area that we have interested ourselves in. Now, I wish to just mention to you briefly about Juliet. Advocate Juliet Komagom Adong is an advocate, as we have already noted. She's practicing in Kenya with the Linda Otieno and Company Advocates. You will also notice that she is a fellow of the Chartered Institute of Arbitrators. She's been voted as one of the best practitioners in her area in Kenya. So we are having the very best before us, and we are looking forward. She also practices family law, and it is an area that interests her so much. So we are honored, Madam Juliet Komagom Adong. She's passionate also about women and children. And I believe that we are going to benefit so much and from her discussion. Madam Juliet Komagom, you're welcome to address us about the Kenya situation. Karibu sana. Miss Komagom, are you there? Hello.
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 Yes, good afternoon.
Yes, please.
Can you hear me?
Good afternoon, ma'am. Yes, please. Yes, we can. Karibu sana.
Asante. And perhaps the Christians have also heard the news that there has been a shooting in one of Kenya's local, at Makadara. Unfortunately, I still happen to not have left
Madam,
Makadara.
Madam Juliet, I would request that maybe.
Pardon? Yes?
Sorry, I think disappeared. I don't know what happened, but there was some sort of disconnection from my place. Hello?
Yes?
I'm just reporting the problem that I experienced some sort of disconnection. Should I proceed from where I ended?
Yes, Dr. Baraka, you
Hello?
can proceed with that.
Okay, thank you. Sorry for the disconnection. I think I was explaining on the contents of a petition for divorce. I said it just looks like any plaint, except that the title should read a petition. And then, of course, the other spouse should also be saved with a copy. And you must, of course, pay the fees. And of course, after that, then the court will conduct a hearing to determine the matter where each party will be allowed or will be heard. And the next thing which I thought of sharing is which courts actually do have jurisdiction in divorce matters. In Tanzania, all courts, starting from the lowest court, that is the primary court, up to the high court, have what we call a concurrent jurisdiction. So you can opt to file your case in either court, whether primary court or subordinate courts. And if you wish, you may even petition in the high court. But of course, as a matter of advice, it is always advisable to file your petition in the lowest court so that in case you lose, then you can appeal to the higher court. If you file it in the high court in the first instance, that means you are diminishing your possibilities or your avenues of further appeals. Then, of course, the court will examine the evidence presented by both parties, and then it will make a finding whether there was a breakdown of marriage and if the breakdown was irreparable. Now, the procedure of petitioning in the primary court or filing a divorce cause in a primary court is very simple. There you can just go orally and you can just raise your complaint to the magistrate. And the magistrate, after hearing the complainant, may adduce the same into writing. But in the other courts, starting from the subordinate courts, the procedure is to prepare the petition and have the same filed, having the same filed. A very recent development, and this will be explaining the current trend. Because of an increase of the number of divorce cases in a highly populated region like Dar es Salaam, actually they have started what is called One-Stop Judicial Center at Temeke. And why is it called One-Stop Judicial Center? That you find all the courts in one place, from the primary court up to the high court. So in Dar es Salaam, you just have one place where you can go if you want to petition for divorce, and that is a one-stop center at Temeke. I think the project is under pilot, and if it works, my assumption is that it will be also taken to other parts of the country. And the reason for one-stop center is that they want actually to expedite and to accelerate the hearing of matrimonial cases, like I said, because of an increase of this kind of cases. So there is only one place in Dar es Salaam where you can petition for divorce, and that is the Temeke One-Stop Judicial Center. In the other regions, the normal procedure, like I said, is to petition in any court, either the primary court, subordinate court, or the high court, depending on your choice. But rules of practice would normally say it is prudent, like I said, to file it in the lowest court so that you can have an avenue for appeal if you lose in the lower court, rather than going to the high court, in which case you will just have one avenue for appeal, that is the Court of Appeal. Now, that was for divorce. Now, post-divorce issues are normally three. That is the question of custody of children, maintenance, and divorce of matrimonial property. And normally when it comes to custody of infant children, normally the factor that is taken into consideration, like in any other Commonwealth jurisdiction, is the welfare of the infant, or sometimes it is called the best interests of the child, and that is found under Section 125 of the Law of Marriage Act. And if you read Section 114, the other matter is division of matrimonial properties, and that will depend on the contribution. But I cited a landmark case. I think this should be read across the continent, the case of Bihawa Mohammed Saif versus Ali Saif of 1983. Actually, it is the decision of the Court of Appeal. This case is landmark because for the first time it introduced the principle that in order to determine the matrimonial contribution towards acquisition of matrimonial property, you don't just look at the monetary contribution. It recognizes that, domestic activities, which may be conducted by a housewife, or even I don't know whether we have a husband, a house husband, like a housewife. Those also will amount to contribution to the acquisition of matrimonial properties. So I think it is a new precedent, and nowadays it has been in application that you see even domestic activities that ensures that one of the spouse enjoys the welfare of marriage, then that also accounts for contribution of matrimonial properties. So you can't just go to court and say my wife or husband is just a housewife or husband-house. It is, I think, like I said, domestic activities also have been recognized as contributing to the acquisition of matrimonial property. And this case, like I said, is a landmark case. So normally the division of matrimonial property is not 50-50. And that is one of the areas that is debatable on how the court may arrive to the conclusion as to the amount of contribution. So that is left actually to the discretion of the court. However, there is a guidance that is provided for under Section 115 that the court may consider, for instance, the direct contribution by any of the spouses, direct contribution in terms of monetary contribution, and sometimes who will have the custody of the children, and sometimes the customs of the parties. And of course, another issue post-divorce is the question of maintenance, and any spouse can file for maintenance, and that kind of application is done in the same court that granted the divorce. Now, what I've noted in my presentation as gaps, or lacuna, lawyers will call it, these are some of the discrepancies, and I would treat this as the emerging trends or emerging issues. One, I noted that there are still some biased provisions. If you go through the Marriage Act, you will notice that there are some provisions which still perpetuate or encourage the continuance of gender bias. For instance, when it comes to the question of custody of children, the principle of welfare will normally take into consideration that, you see, the basic needs of the child, like education, food, the basic needs, provision of the basic needs. And now, because most husbands or most men are very much economically powerful, that kind of provision tends to favor them. The other area of ambiguity which I noted, like I said, there is a lack of clarity on what amounts to a retrievable or irreparable breakdown of divorce, or even the principle that can be applied on division of matrimonial property. And sometimes, how do you know that this is a competent marriage conciliation board? I came across a number of cases debating on these issues. And because of this, you have a number of cases with inconsistency. That's what we call conflicting judgments. But the other issue which also I consider as a discrepancy is that because of clear guideline, like what amounts to non-monetary contribution, like how much do you, for instance, gauge matrimonial property? I mean, domestic activities when you're assessing the acquisition of matrimonial properties. So there is no clear guideline and there's no clear formula to apply. That will depend on the discretion of the court, and actually that has also invited a lot of debate, and it has caused some kind of uncertainties when it comes to divorcing parties. Again, the other issue which is controversial is when it comes to division of matrimonial property in a marriage that involves polygamous kind of marriage. Then you don't know what are the rights of the non-divorcing spouse. And there are no clear guidelines on what can be the principle when you are dividing matrimonial properties in a marriage involving polygamous kind of marriage. The other issue which I noted is economic barriers. Usually the high cost which are associated with, instituting divorce proceedings. And many individuals, especially women, because they are economically disadvantaged, you cannot afford the cost of hiring, say, an attorney. So perhaps an advice is to use the primary court, which you can just go to a magistrate and raise your complaint orally. But we also have the problem of access to legal aid. Like I said, access to justice can be a problem because some of litigants may not be economically advantageous, and particularly women, and because it is a technical process to go through, hiring an advocate may not be an easy process. But the other question is the question of limited knowledge and awareness. You see, most people are not aware of their marriage rights, especially in rural areas. And some people are still thinking divorce can be just granted by a pronouncement by the husband, especially those who observes Islamic faith. I also noted that there are still some elements of cultural and religious conflicts. If you read the Law of Marriage Act, there are some remnants of, elements of customary law, religious law. And because of this, you always find some sort of conflict between the customary and the religious practices. For instance, usually under customary law, they would want the divorcing wife, for instance, to pay the bride price back. But under the Law of Marriage Act, then that is not a requirement. So that may attract some sort of conflicts. But because of that conflict, as I also noted that it may also complicate divorce proceedings, especially where you have practices that are discriminatory against women. And like you will all agree that actually the Law of Marriage Act tries to accommodate both customary norms, religious norms, and as well as some elements of statutory law. And the other issue which I mentioned earlier is the recognition of polygamous marriages. And because of that, it attracts a lot of complexities, especially when it comes to division of matrimonial property, where you have one of the one divorcing wife and the other non-divorcing wife. And then the question is, what is the justice for the non-divorcing spouse, for the non-divorcing spouse? This is a continuation of emerging issues. I think it looks like a repetition of what I said. Gender inequality, we still have some remnants of gender equality, and women in some cases do face difficulties in proving grounds for divorce, especially in cases of adultery, cruelty, and desertion. Because, like I said, our society is considered to be promiscuous. So for instance, a single conduct of adultery conducted by a husband may not be sufficient to prove that the marriage is broken down irreparably. Another emerging issue is access to justice. I think this is one of the significant issues, particularly for women. I addressed the question of high legal costs and the lack of legal aid scheme for civil cases, and that may impede, access to justice for those who seek divorce. I also identified the question of HIV/AIDS, and now the question is, there are those spouses who enter into a marriage knowing the HIV status. They know that they are HIV positive, and they not disclose this to the other spouse. And the question is, if the other spouse discovers, for instance, would that be a sufficient ground for petitioning for divorce? And I have come across a number of such kind of disputes. And then the discussion is whether HIV, AIDS, and other contagious diseases should also be included in the list of evidence to prove that the marriage is broken down. I think I just have one slide to wind up. But the other question and the other emerging trend is that there is a problem when it comes to division of matrimonial property when you are involving business and professional assets. You see, there are some spouses who tend to incorporate or to create some business entity like companies for the purposes of hiding some matrimonial properties under the corporate veil. So they will just register a matrimonial property as the property of the company, so that during the divorce process, then it will appear that the property belongs to the company. And that is, I have noted this in a number of occasions. Finally, I have concluded by saying the landscape for divorce law and the practice in Tanzania is still evolving, and there are several emerging issues requiring attention. And I have, noted that the procedure for divorce law, as outlined in the Law of Marriage Act, involves a number of multiple steps, and they are there to ensure what we call just dissolution of marriage. There are several issues, emerging issues, like I have indicated, and therefore, to address these issues, perhaps we need some reforms. For instance, we may need a provision which addresses the question of division of properties when the divorcing parties are in a polygamous kind of marriage. And because of lack of awareness, I have suggested that we may need to increase some awareness of legal rights, and that may actually ensure that there is equitable access to divorce process. Having said so, I think that was my last slide. Thank you for your attention.
All right, thank you, Dr. Baraka. Sorry, I realize now that we had cut you halfway, or should I say quarter way. Asante sana, Dr. Baraka. We have been so much enriched. I realized that the law in Tanzania is called the Law of Marriage Act. Quite interesting. And it's been quite an educative kind of outing of what it is actually in Tanzania, how to submit to jurisdiction, how to start, the fact that you should start from the lowest court. It's quite good advice for that as far as clients are concerned. the element of matrimonial property, how different that is. We shall be hearing what it is in Uganda, Burundi, Tanzania, and rather Kenya and DRC. So I thank you so much. I request that at this point, let us now move to Kenya. Madam Juliet, kindly come forward. And I wish that we now try to manage the time. Let us try to work within 25 minutes so that we can all hear what it is within the region. Madam Komagom, over to you. Madam Komagum, I already introduced you. Kindly just come in. It's your turn now.
Yes, hello, good afternoon.
Good afternoon. Karibu sana.
Asante sana. And perhaps our participants perhaps may be getting the news that that a Kenyan magistrate has been shot. I happen to have been on the crime scene, and the evacuation is still taking place. So I'm not able to use my laptop, so I'll just deliver what I had open, because the atmosphere in which I am does not enable me to do a comprehensive presentation, but I'll do it later.
Oh, sorry about that. Very sorry.
Someone walked in with a pistol, and I waited for the hearing to end. And after the magistrate read out the judgment, he pulled out his pistol and shot the magistrate in the thigh. So she's been rushed to hospital. Unfortunately, she was neutralized by the court orderlies and his colleagues.
Sorry about that.
But back to marriage. In Kenya, marriage is governed by the Marriage Act 2014. This is the new Marriage Act that was brought in place, having the old one was repealed. The thing about the new Marriage Act is that it tries to accommodate all the marriages under one. You have the Hindu marriage, you have civil, you have customary marriage, you have the Christian marriage. Customary marriage is there's no provision for customary marriage to be registered. There are forms that you fill in for the marriage to be for registration, and it has provisions that there must be two consenting adults. The rights of the rights of the parties must have been concluded. So now you can now not go to court and say that I was in a customary marriage and therefore I have no certificate. There's no provision for customary marriage to be registered. As of August 2017, after August 2017, and before August 2017, there's provision for customary marriage to be registered. The other one is the Hindu marriage. Hindu marriages, apparently, initially, marriage certificates were being given by, if it is Hindu, you get it from the Hindu temple. If it is a church, it will be given by the church. But now, they must all be reserved at the attorney generals. So whoever is officiating the marriage picks the certificates and their copies that are retained at the attorney generals. This has brought in a lot of order. Initially, we used to have a lot of incidences. You have people traveling to the US. Some of them were married before. They'll come up and say they are not married. Some of them will go to Dubai or US and pick a phone call and ask their pastor and say, could you please help me with a leaf of the marriage certificate? Today, you can't now do that. And those are some of the issues that the Registrar of Marriages deals with. People who want to connive to conduct marriages, and yet they were initially married and they've not dissolved the previous marriage. So now, before you now get married, at least the registrar will know at the attorney generals, because even the churches are required to pick copies of marriage certificates from the attorney generals. Islamic marriage has the Marriage Act only says that that has been left to the Qadi courts. So the Qadi courts have the rights to declare a marriage, to declare divorce, according to the marriage culture, according to the Islamic the Islamic rights. Let me talk about dissolution of marriages. I think initially there were about 4 grounds of divorce, and a divorce is also called a divorce petition if you want to nullify, or if you want to apply. Pleadings for divorce are also called petition. A petition, you file a petition. Advocates love this a lot because this is the simplest to do. It doesn't have a lot of issues. You draft a petition, it's called a petition. You draft a petition, take it to court. It has a witness statement in which you narrate the story of the party, a verifying affidavit. Then there's the marriage certificate. Usually doesn't take a lot. Then you wait for the decree is given after 1 month. So it's usually not a very big deal. I think this is an area where even self-representation really doesn't have much, because all you need to do is to plead the grounds and prove the cruelty, desertion, exceptional privity, adultery, and then of course there's the recent one, which is an irretrievable breakdown of the marriage. And some of the examples have been constant quarreling, that you can't agree, you're constantly shouting at one another, you just can't agree, you can't communicate. Someone left the matrimonial home more than a month or more than weeks and left and has never returned. But people can no longer stay together. There used to be a window period of 6 months to see whether the marriage can still be salvaged. But over time, I've not seen the Kenyan courts observe that. That rule was done away with. So that today, if you apply for divorce, all you need to do is wait for 30 days and you'll be granted. Have I seen couples who've tried reconciliation after? Yes. Recently, I was in court at Thika, and a lady who had filed for divorce now has second thoughts. She no longer wants a divorce, so she had gone back to court to plead with the court to give her another chance. I'm still waiting for the judgment, because as of the day we were in court, that was last week, the magistrate had not decided, because then the husband to the marriage did not show up. He only sent his advocate. And for us, when a party sends his advocate, as opposed to him coming in person, that is a communication that perhaps he's not interested, but we are yet to see how it goes. Another matter that reconciliation prevailed was one that was referred to mediation. It was they had divorced already, and they were at the point of division of matrimonial property. So this matrimonial home was the bone of contention. Both parties wanted the matrimonial home. Both the husband wanted the matrimonial home. The wife was insisting on being given the matrimonial home. And it was discovered that this matrimonial home had a bar in the backyard, in the front. The front had a bar, a pub, a beer pub, a beer parlor, you could also call it that this couple used to run. So the husband offered to subdivide the matrimonial home and set up another pub for the wife. But in the meantime, now that was during mediation, because when the court looked through it, it was a bit difficult and they couldn't agree. So the court referred the matter to arbitration, to mediation. I'm sorry, to mediation. So during mediation, the husband offered and said that he would subdivide, he would build a wall. Then one side should be left for the wife and the other side should be left. But in the meantime, he offered to pay the wife, since the pub was making money. So in the process of how much money have you made today? How is business? they reconciled. Of course, they reconciled, and that is how the file closed. Of course, the Kenyan courts, I think nowadays, this is a personal opinion, I have not seen courts that are being deliberate about holding the marriage institution together. Because when I look at all the decisions that are coming out, you don't see a decision that is trying to encourage couples to stick together, or encourage couples to, why don't you give it another chance? No. Because then, let me talk about civil marriage. Civil marriage, initially, when civil marriage was being, when the civil marriage, initially there was a rule about civil marriage that you cannot file for divorce after you contract a civil marriage unless after you've lived together for a period of 3 years. So Court of Appeal came up and said that rule is unconstitutional. You cannot force two consenting adults to live together when they are not interested. So now you do not have to wait for 3 years for you to petition for divorce if you had contracted a civil marriage. All you need to do is go and petition court, let court decide. Initially, there was a barrier that you can only petition court for divorce if you have contracted a civil marriage for 3 years. Now it is not the position anymore. So that is the other. I hadn't intended to talk about the distribution of matrimonial property, but let me just touch it offhead. Matrimonial property has become very contentious in Kenya. Can you hear me?
Yes, I can hear you.
Okay. I'm sorry, I have a lot of distractions. So I was talking about matrimonial property, and I was saying there's a lot of matrimonial property has become very contentious because of a recent Supreme Court decision that a cohabitation does not amount to marriage. Because unfortunately, in Kenya, we have so many cohabitees. Cohabiting means people who come together and live together under presumption of marriage and do not take it upon themselves to formalize the marriage, to either go to either, like in other jurisdictions that I know, where parties will visit the lady's parents, maybe pay dowry, maybe have a wedding, maybe do a civil marriage. No, in Kenya, we have so many of such couples who just came together and started living together. And over the years, initially, it used to be called presumption of marriage. Courts used to recognize presumption of marriage. Now, presumption of marriage means that you're presumed that you're married. So you would enjoy all the benefits attached to people who are married. If it is inheritance of property, if it is a division of matrimonial property. In fact, before this landmark matter, before the landmark case, 6 months, if you had lived together for 6 months, it would be presumed that you are married. And unfortunately, recently there was a landmark case that said cohabiting is no longer recognized. And there's nothing like presumption of marriage. If you're married, you're either married customarily, you're either married civil, you either contracted a civil marriage, you either did a Christian marriage, it must be one of those. You can now not just wake up and say we've been cohabiting for 2 years, and for that matter, treat us as married couples. No, When you now go to court, you must now present a marriage certificate. Devoid of that, the courts do not recognize you as a married woman. So now there are so many women who are still caught up in that quagmire of that this person stayed in a relationship for long. The relatives or the in-laws know her and acknowledge her, but when it comes to now the serious issues, when you now go to court and say, I now want division of matrimonial property, then they will now say, prove that you are married to this person. 2, prove contribution. Initially, contribution in kind was acknowledged, that I was a housewife, I was washing his clothes, I was taking care of the baby, I created a good atmosphere for him to thrive in his career. All that was acknowledged as contribution. To date, you can now not say that. Depending also on how your counsel argues your case. In some instances, it will be hard. In some instances, it will not be hard. But that is the thing that has happened in marriage, and that has brought a lot of cracks. It has created a lot of issues, because you now have people who don't want to. A woman, initially, women would it wouldn't be a big deal if you buy a plot of land together, and it is registered in the man's name. It wasn't a big deal, because then the family just assumes belongs to the two of you. As of that decision, it has now ruffled a lot of emotions in marriages, because now you have to prove your contribution, that this parcel of land I contributed. How much was your contribution? Is it 30%? Is it 40%? Because now court came and said, you now can't say you're entitled to 50% of everything that you acquired during the marriage. You must now show that contribution. You must now prove that contribution. And we all know how difficult it is to prove contribution where you're in love. That you gave your husband 200,000 Kenya shillings and said, this is my contribution for the other plot of land. Would you have him sign an agreement? Surely no. Would you have him sign a contract that, we are constructing this house, and can you sign here? That is difficult. So that is what has been created. The other thing is that now I see a lot of prenuptial agreements where people are coming up and saying, before we get married, then you start claiming my property. As we enter this marriage, these properties that I have acquired will not form part of the matrimonial property. That will be just mine. So that even as we come together as man and wife, or as husband and wife, anything we acquire going forth is now between you and me. But anything that you had acquired before, I cannot lay claim after the marriage comes to an end. Or anything that you had acquired before you came into the marriage, the other party cannot lay claim that forms part of matrimonial property. Because I think also that was becoming an issue where some women were being accused, even men were being accused of contracting marriages just for the benefits, especially property. So that now after some years, they'll come up and say, I'm entitled to this property because I'm your spouse. No. Now that is not the issue anymore. You must now prove. If you contributed to something in the marriage, you must now prove. If you contributed to acquiring a vehicle and you now want it distributed, you must now prove, what did you contribute to acquiring that vehicle? What did you contribute to acquiring this house? What did you contribute to acquiring this parcel? What did you contribute to acquiring these shares? Those are some of the fights that I see in courts now. And perhaps I should also state that Kenya is also a fault. The Kenyan marriage system is also a fault-based system. You can't say that you can't go out of a marriage, do something, then come and say, I want a divorce. Your party must be at fault. Kenya does not recognize divorce by consent, where the two of you will sit down and say, I think we're just tired of this. But you can do consent, in other words. How? By not responding, or by not putting in a cross petition. That your partner will have accusations, they'll do a petition for divorce, and you will not respond. Then a divorce will just be granted, irrespective of whether you responded or not. I think that will be all for now. I'm sure there are so many things that I've not covered, but being at a crime scene, I think I would also want to leave. So I'll be waiting for the questions if I can answer them. Thank you.
All right. Thank you. Thank you, Council Komagum. We certainly appreciate as for what has happened in the background. Poleni sana. We certainly appreciate your expose of what is happening in Kenya as far as that legal terrain is concerned. We noticed that you have a comprehensive law, which is called the Marriage Act, which provides for all kinds of marriages. And we noticed that your law is quite comprehensive in many aspects, as opposed to we shall be hearing how the Ugandan terrain is. And we have also seen that your laws have eliminated time periods for when somebody can
I've seen that Gabriel is not online now. Can you hear me, please?
Yes, thank you so much, Dr. Modest, for pointing that out. We, like my esteemed moderator, Mr. Ejoko has mentioned, we are crossing over now to take our discussion to the landscape in Uganda. And this afternoon, we are profoundly honored to host Dr. Harriet Diana Musoke. Dr. Musoke is a lecturer, and she's been mentoring students in the legal profession for a very long time. She lectures family law, human rights, women's rights, health law, in particular reproductive and sexual health rights. Dr. Harriet gained her LLB from Makerere University. She did an LLM with distinction from Georgetown University, and her SJD from Emory University School of Law. Her research area was on how reproductive sexual rights, as conceived by international community, can be Africanized in order to ensure that all women in Africa enjoy these rights. Dr. Harriet practices law in Uganda, and her area of interest is family law, children's issues, women issues, and human rights concerns. She's on a number of boards, including the editorial board of the Uganda Living Law Journal, and she's a member of the Uganda Services Bureau. She's a former president of the Uganda Law Society, which makes her senior counsel. She's a member of the Uganda Law Society. She's also a member of the Uganda Association of Women Lawyers and a member of the East Africa Law Society. She has published a number of academic articles and presented a number of papers. Her research interests mainly in reproductive sexuality, children, and human rights. Dr. Diana, we are profoundly honored and exceedingly humbled to host you. And right now, I'll invite you to come and make your presentation on the law and procedure in Uganda while sharing the emerging trends. Over to you, Doctor.
Good afternoon, everybody. Can you hear me?
Yes, good afternoon.
Yeah.
Yes, Doctor, we can hear you. We kindly
Yes,
request that you turn your video on, if possible.
Yeah, the video, my problem is that network here is really very bad. So, but I hope you'll be able to see me. But at one point, maybe I'll switch off the video. But in the meantime, I can make the presentation. Good afternoon to everybody. I am very glad to be part of the group discussing issues on practice and procedures in divorce. and specifically in Uganda. I'm sorry, I don't have a presentation, but I have put up all the work that I need to present. Now, like my colleague in Tanzania and Uganda and Kenya said, when we look at issues of divorce, I think we have the same procedure, and all that the procedure is by way of petition. But before you can have a divorce, you definitely must have a marriage, and it must be a legal marriage. And in Uganda, we have a number of recognized forms of marriages, and we also have different types of laws that govern these marriages. We have the civil marriages that are held at the registrars of marriages office, and we have the church marriages, and all these are governed by the Marriage Act. We then also have the customary marriages, and these ones are governed by the Customary Marriages Registration Act. We also have the Hindu marriages. These are governed by the Hindu Marriage and Divorce Act, and also the Mohammedan marriages that are governed by the Marriage and Divorce of Mohammedan Act. Now, all these marriages, of course, they have their different procedures on how they can be conducted, but then all of them can also be ended by having a divorce. Now, as I was introduced, I practice family law, but when a person comes to you and a person wants a divorce, there are areas, issues that we have to look at when we are looking at to help the client. And I have looked at each of them separately, and of each I have also discussed the emerging trends that we are having here in Uganda when it gets to issues of divorce. Now, when a divorce matter comes before you, the first thing that you have to look at is, where is the jurisdiction? What I have to look at if I'm going to have this divorce. And then you look at the grounds for divorce. And then you're also going to look at the orders, the kind of prayers that you are going to put in the divorce. Now, when it gets to jurisdiction in Uganda, of course, it is where this will depend on where the parties are resident. If they are Ugandans and both are citizens, then you'll go to the magistrate's court, which is a court of note of record. And if there is one of the parties that's a non-citizen, then you can go to the High Court. Now, the issue we are having currently in relation to jurisdiction is or are you also going to look at an issue where there is matrimonial property? If the property is above the jurisdiction of the court, can the magistrate's court hear that matter? So we are having conflicting judgments where some courts have held that if your petition is for divorce, then that is why you are in court. All these are and see what do we look at. The aspect of where do you go when you are looking at the issue of jurisdiction. Now, this also the issue of jurisdiction also will bring in the issue of domicile. Now, under common law, which all our systems have, under common law is that a woman, once she gets married, she takes on the domicile of her husband. So if she takes on the domicile of the husband, then she has whichever the domicile, then it will become their domicile. Now, there have been a number of cases that have been discussed, the case of Chigundu, the case of Robina Chinji. All those were that as soon as a woman gets married, then the woman takes on the domicile of the husband. But then we've had recently, not a very recent case, but we've had a case, it's a 2018 17 case, the Hogg versus Hogg case, where now the courts have decided and say that it is not automatic that as soon as a woman gets married to a man, that she takes on the domicile of the husband. The woman can remain with her own domicile, and therefore she can be able to file a petition in the domicile that she wants, or the domicile that she has remained with. It is still an issue where a matter comes on and say, no, the domicile of the man must be the one to be taken on by the woman, and that she doesn't have a choice. But here in Uganda, we have that, and I don't know whether that is also the same with the other countries, but here in Uganda, a woman does not automatically take on her husband's domicile. Therefore, she can petition for divorce using her own domicile. Now, another challenging emerging trend that we are also having in relation to jurisdiction in Uganda is in relation to our brothers and sisters who profess the Mohammedan faith. Now, when you look at our Article 129 of the Constitution of Uganda, it provides for the different courts that we have: Supreme Court, Court of Appeal, High Court, Magistrates Court, and any other courts that can be established by Parliament. And the Constitution provides for that there will be established Kadi courts to deal with the marriage and divorce of the Mohammedan. Now, by that mention itself, there are issues in the procedure and the practice as to whether the courts have actually been established. There are judgments which come up and provide that because they were mentioned in the Constitution, therefore it means they were established and you can have the divorces under them. In other judgments, it says no, because the procedures have not been provided for as of now, therefore it means that they are not established, and that if the Mohammedans, those who profess the Mohammedan faith, have to come to go to the secular courts, to the High Court, if they want their matters to be done. So it is an issue that is coming up, and it's a trend where we are now finding, if we're looking at the practice and the procedure, where both parties profess the Mohammedan faith, what is going to happen. But at least what is clear now is that at least in one of the cases, Nawawanuka versus Makumbi, the courts held that the Mohammedan Act did not oust the jurisdiction of the High Court. Therefore, if parties profess the Mohammedan faith, they can still go to the High Court and their issues can be dealt with in the High Court. So that is one of, when you're looking at the practice and procedure in Uganda, is the issue of jurisdiction. And as I've discussed, it is something that we have on. Then another aspect that when you're looking at the practice and procedure in divorce is that the grounds for divorce, okay? Because of course, if you're going to have a divorce, then you must have the grounds on which you are going to, you must base on. Now, when you look at our marriage laws were all laws that were enacted before we got independence in 1962. Now we have laws, for example, the Marriage Act is a 1935 Act. Some of them are 1907 Act, but we still have them in Uganda. Now, when you look at the grounds for divorce under Section 4 of the Marriage Act, and when you look at all these types of marriages, they have their different types of the grounds. It provides that the man has only adultery, and the woman was given a number of them: adultery with cruelty, adultery with desertion, sodomy, change of religion, rape, and bestiality, incestuous adultery. All those are very many grounds that were given to the woman. So in 2006, I think, the Uganda Association of Women Lawyers went to court and said that, prayed and said that giving women very many grounds and only one ground to the man, that was unconstitutional because it was discriminatory, it was not equal, and so on and so forth. So the Constitutional Court interpreted this particular section and held that yes, it was discriminatory in as far as it was giving the man only one ground and the woman so many grounds. And it's in conclusion.
Doctor, I think we have lost you. I don't know if you're able to hear us.
Hello?
Yes, doctor, we had lost you. Now we can hear you.
Oh, okay. Thank you very much. I'm sorry. Network is really very bad.
Perhaps
So,
you can turn off the camera so that we leverage on it.
okay, let me turn off the video. Okay,
thank
so
you.
thank you. So now with that case, with the feeder case, now parties can be able to. This coupled with the case of Kaziwe versus Kaziwe, where the court held that one ground for divorce is enough for a party to be able to have the divorce. So this means, therefore, that currently, with the practice and procedure, a party has to prove only one ground for divorce, either adultery or quality or desertion, change of religion, all the way they are stated in the Act. You just have to prove only one of those grounds, and then you can be able to have a divorce. Now, in Uganda, we do not have a no-fault divorce. You cannot simply say, I am tired of you. I now want to unlove you, and therefore we should have a divorce. You must have a ground for divorce, and you must prove that there is a ground for divorce. And also in Uganda, we do not have a time period when to divorce. You don't need to have stayed together for 2 or 3 years before you can divorce. But of course, when you bring up a matter, maybe 6, 7 months after divorcing, of course, the courts can use its discretion and see how they can be able to help you. And like all the other Kenya and Tanzania, of course, there is the courts usually want to have a reconciliation and see if the parties can get back together. But where they can't, then you have to prove the ground, and then you are able to have the divorce. Now, once you petition then for divorce and you want the dissolution, we have a two-stage divorce. You have the decree nasi first, and then after 6 months, then you can have a decree absolute. And those 6 months is what they call the cooling period, to see if you can be able to get back together and be able to continue with the marriage. When we look at customary marriages, the customary marriages is once you are married customarily, then if you want to divorce, then you should divorce according to custom, okay? Because that is the procedure that you took on when you are having the marriage. However, recently we had a case, and it was a constitutional petition by an organization called Mifumi. Now, in that Mifumi case, the issue was because under most of the customs that we have in Uganda, if you are going to divorce, then you have to return the bride price. That was the form in which the marriage could be dissolved under customs. Now, under this Mifumi case, the Constitutional Court ruled that the return of bride price is unconstitutional. Therefore, if your custom, if you want to dissolve a customary marriage and the procedure is by way of return of bride price, that procedure is now wrong and it was declared unconstitutional, which therefore means that for those customs where the return was bride price, now they can have to go to the courts, and then the courts will be the ones that will be able to dissolve that kind of customary marriage. And this one was also discussed in the case of Muwanga Chintu versus Gafa Busa Chintu, where also the court held that the High Court has jurisdiction to hear and dissolve customary marriages that were conducted, and the court was able to deal with that issue. Now, when we are looking at dissolution, the practice we've been having in Uganda is person petitions for divorce. The respondent also wants the divorce. So the advocates, they sit with the clients and then they say, let us consent. And we have a consent judgment, like in any other civil procedure where a suit is brought in court and the parties sit and they consent and then they draw out a consent judgment. So we have been having consent judgments in divorce matters. And the issue now is, when we were drafting the consent judgment and the parties signed them, no ground was indicated. Now the courts provides that if you're going to have a consent judgment, you must put in a ground. And the issue here is this good practice. Should we have consent judgments once one of the parties has petitioned? It is a practice that is on. It is not provided anywhere in the rules, but because divorces are also civil procedure, that's why we get the idea. We get the notion that you can enter into a consent judgment. So that is a practice that we look at and we see that we have when we have these matters in Uganda. Now, in addition, when you have the dissolution of the marriage, then we also have the issue of child custody and child maintenance. Now, because we have a patrilineal type of society, it was what we used to have is that the man or the father provide for maintenance of the children, everything, education, medical, school fees, and so on. And then the children, the mother would stay with the children, and then she would give them the nurturing and so on. But with the Children Act of 2016, which provides that both parents have the duty to provide and maintain the children, now the courts look at the financial aspects of both parents, and now we are having shared maintenance, where for example, court can order that the father pay for education and medical, and you, the mother, provide for the everyday needs and then the shelter. So the courts are now moving away from looking at this aspect of the man, the child belongs to you because of the system that we have, then you have to take on all the responsibilities. So that is one aspect that is coming out, and the courts are looking at the issue of the maintenance of the children, and they're having the mothers getting more involved in the maintenance. But of course, all this is dependent on the financial capability of the mother, because most of the women, they are either not working or they are in low-paying jobs. So that matter comes up. And another emerging trend also that comes up in relation to children and in Uganda is the issue of legal custody. Before, when we were talking about custody, we assumed it was physical custody, where the court would give sole custody to one parent, and then the other parent would give joint custody. But now a lot of emphasis is coming on the issue of legal custody. And I think it is becoming common on legal custody, one, because of having, there is an increase in intertribal marriages. So the issue of who is going to make the decision of the future of the children to bind is coming up. We are having many interreligious marriages, although people, somebody can be a Muslim, convert to Christianity, go on to the church, but still, because you were born somebody and is under the Islamic faith, you may still want to practice that. So that is an issue that comes up when we are looking at making long-term decisions concerning children. So legal custody is also becoming very common now. And many people, when they're talking about custody, they are not only talking now about physical custody, but they also want a decision to be made in relation to the legal custody, who should have legal custody of the children. So that kind of the practice that we have, but now it is an emerging trend which we have to look at and see how it can be will be handled. Now, another matter that comes in when we are looking at the practice and procedure in divorce is the issue of matrimonial property distribution. And like my colleagues have said, this is the most touchy of all matters when it comes to distribution. Now, what amounts to matrimonial property at first was really an issue because it was difficult to understand what amounts to matrimonial property. But at least in the case of Rabinomi, which is a Supreme Court decision, and it made reference to many other cases, it said matrimonial property should be joint property. And this case, why it's a really interesting reading is that it provided that matrimonial property is property jointly owned, which both of you agree it should belong to both of you. But it went also ahead to state that even when you are married, you can own property separately, meaning that you can have a house where both of you are joint, it's joint, and then you can also have your own property, which you don't want your husband or your wife to know about, or even if they know, but they are not, it is not their concern. So at least here, it has now become clear. And when we get to issues of distribution, we have to determine what amounts to matrimonial property. And anything outside that, it will remain the property of the different spouses. Now, once you determine the matrimonial property, how is it distributed? The good thing also in this case of Rabinomi is also discussed that you look at contribution. It is not 50-50, but what have you contributed in order for you to get your share? Now, in the case of Muwanga Chintu and Gafausa Chintu, which is a high court case, but which was also very good. It also dealt with this issue of property. It discussed the monetary and non-monetary contribution. So now when we are looking at distribution of matrimonial property, we find out if you brought the money, but this other person looked after the home, cared for the children, cared for you, how do you compute that? The courts go ahead to even compute if you are a housewife, full-time housewife, and you don't even have a house manager or a house help, how much, all the time, and they look at that. The kind of position the husband or the wife has, how have you been able to contribute in that emotionally? How have you been able to have this person be able to work and to sustain the home? There are instances where you can agree and the person says, or the husband says, let me contribute to the building, and you as the wife, you maintain the children, you pay for the education, such that you distribute the roles. So all those, the courts have looked at it, and I think it's really fair to both parties, because why look only at the monetary contribution and you don't look at the non-monetary contribution? Because it's also very, very important if you are going to have people continue working. So in practice and our procedure, when we are looking at the issue of praying for matrimonial property, we have to distinguish between that and that which is singly held, and also what was the contribution. The courts, in the case of Mayambala and Mayambala, the court gave the wife 70%, and the husband took 30% of the matrimonial home, because the wife showed that she contributed a lot of financial and all the the non-financial support. So as we're looking at the issues of distribution, it is not automatic that the husband or the father will take more, but the wife can also get a bigger share depending on the contribution that she has made. Now, one interesting aspect which I just want to point out here in the practice and procedure which we have in Uganda is cohabitation is not a recognized form of marriage. So even if you have been living together for 20, 30 years and you didn't go through any form of marriage, then you are cohabiting, then the issue of matrimonial property does not even arise. However, recently we had a matter, and that is the case of Chigongo and Chigongo. It's a 2015 case. Now that case was the court ruled that there was no customary marriage. These people were just cohabiting, but then brought in the aspect of matrimonial property, and then also how the wife was entitled to matrimonial property. It is an issue which we are having a debate about. Is it now that Uganda, we are trying to, I don't know whether in a gray way, trying to recognize cohabitation, which is not the case, or is it a matter of judicial activism where there's a cry out to the parliament and say, please, can you make us a law where you can be able to protect people who are in cohabiting situations? So it is something that came up where we had a mixture of cohabitation and matrimonial property, but it is also a matter that is being debated, and as we go along, maybe we'll get to see how it is done. But otherwise, cohabitation is not recognized in Uganda, and therefore you cannot, cohabiting parties cannot even talk about divorce or cannot even talk about distribution of property. Now, another area that comes up when you're looking at the practice and procedure in divorce in Uganda is the area of alimony. The alimony who giving maintenance to the wife. Now, in practice, what we've been having, it has been the man to maintain the woman, to give alimony. Why? Because of the presumption that when parties get married, the husband takes on the obligation to look after the wife, and also the fact that the man says he's the head of the house. So if he's the head, he has to continue providing for everybody in the home, even when they're separated. That should be so. Now, when you look at we had a case of Ayiko versus Leku, which looked at this right to alimony, as was discussed. Now, courts, on the other hand, are providing that, yes, the man should be able to provide, but where the lady is working and she has money, if then the man is ordered to pay alimony to her, the courts have looked at it as unjust enrichment. So the alimony has not been granted to the woman because that would be unjustly enriching her. She already has a job, and then she will also be milking the man, who then has to provide for the children. Now, interestingly, when you look at this issue of alimony, in the case of, that was in my practice, maybe there were other cases I was not aware of, but in my practice, that was the first case which of Kazwe and Kazwe, where the husband prayed that the wife should give him alimony, because the husband was an engineer working on and off, and then the wife was a high-ranking person in the government, and she had a lot of money. So the husband said, let her also pay me alimony, because the husband, my status in life has been of somebody high. We have lead cars, we have the kind of house we have been staying in, and so on and so forth. But the court held and said, no, a woman has no obligation to provide alimony to maintain you as a man. So alimony was denied. So this is an area which we're looking at on the issue of alimony. Should it continue remaining when we are looking at the practice of divorce, or it should not be a right for the women, for the wives, but and then it should also come up and that once a woman is richer, then the woman should also provide alimony to the husband when they are divorcing. So it is an area also that is coming up in our practice and in our procedures in Uganda. Now, just as Judith said in Kenya, in Uganda also the issue of prenuptial agreements is becoming very common. And it's becoming very common because many people, I don't know where they got the idea from, they think people get married in order to snatch the other's property. The man says, the woman has gotten married, she wants to take my property, to share in my property. Women say that when they have property, when the men come in, they also want to take their property. So the issue of prenuptial agreements has also become very common. And what we haven't had yet, even a test case, is it like any other agreement and therefore it is enforceable, or it should not be enforceable? So it is an issue and a new area that we are looking at and see, as we have many of these prenuptial agreements, should they be enforceable like any other agreement, such that at the time when the parties are going their separate ways, should we consider the property that they got before to make it as joint property, or we shouldn't look at it in that way, especially when you have a prenuptial agreement, but then when you get married, you stay in the house where you say that is my home, but then you have made it your matrimonial home. So the issue also comes up, and it's an area also that we are looking at when we're looking at the practice and the procedures and divorce matters. But otherwise, I've looked at all these particular aspects that we look at, and then I have looked at emerging trends that are coming up and where we have issues that we have to tackle. And I don't know about the other countries, but I think still applicable, or a 1935 Act being still applicable in this millennium, but that's the way it is. And maybe what we'll do is to call upon our parliament to see that we have these laws amended, and then we can have, look at what is happening in the country presently. Because when you see there has been an attempts to have the laws amended, but there has been a lot of forces that have made it very difficult to have the marriage and divorce bill. Some say you can't have marriage and divorce in the same act, because you can't say you're starting something and you're ending it and it's all in the same law. So we are still having those challenges. Here in Uganda, we are going to deal with the issues of divorce in Uganda. But otherwise, that is the practice that we have, and we look at it, looking at the different marriage, the procedures. But if you are going to court, all of them are by way of petition, and I believe we have the same provisions that we put, like in the other countries, like our colleague from Tanzania, who was telling us what has to be in the petition. I think even in Kenya, I think they're all the same, the procedures that we have. But most importantly, one thing is that you must prove that there was a marriage. If there was no marriage, then you cannot even talk about having a divorce, because the courts will not be able to look at that. And of course, when you look at all these marriages, all of them have a marriage certificate. Maybe only the customary marriages, which are conducted in the homes and where, but now the courts insist, and as is provided in the Act, that the customary marriage must be registered. And then once it's registered, then you can have the certificate of marriage, and then you have to be able to prove the marriage. If and once you prove it, then you can talk about divorce. So in summary, that is the practice and procedure which have in Uganda, but we don't have a no-fault divorce. You must prove a ground for divorce. And what usually most people bring up as a ground for divorce is cruelty, because cruelty is amorphous. It can be physical cruelty, it can be emotional, it can be mental. So many people can play around with that ground of cruelty, and then they can bring up all that, the nagging, denial of sexual intercourse, excessive demand of sexual intercourse. All those are issues that you have to look at, but the only thing you have to consider here is how has it been able to affect the person, and then you can be able to convince or to prove that there was a ground, and then you can have the divorce. I don't know whether I've been within my time or have exceeded my time, but I've just given you, and it's just a brief, an outline, because in 25 minutes, it's very difficult to be able to get into the nitty-gritties of the practice and procedure of divorce in Uganda. Thank you very much. Over to you, Samuel or Gabriel. Thank you very much.
Thank you. Thank you, Doctor. Thank you very much, Gabriel. Are you able to hear me, just to be sure?
Yes, we do confirm.
We can now hear you.
Oh, thank you very much, Dr. Diana. We are so much privileged to have had you, Senior Counsel. I think many of the Ugandan lawyers who are on this call were certainly taught by you, and they can confirm that you are their guru. And certainly, I think that has been a we have found parallel as far as the practice is concerned. I don't know, it would be good to later on hear whether Kenya and Tanzania also have a two-stage process of divorce that allows for a cooling off period. And we've heard about the frowning of the law on the question of agreeing to divorce. It's the same thing here. The question of contribution to monetary or otherwise to matrimonial property. The question, the gray area of cohabitation. The Ugandan law itself seems not to accept the concept of cohabitation, but the practice in the courts makes us wonder whether it is being tacitly accepted or not, given the Chigongo and Chigongo case, the alimony, questions of unjust enrichment, if what the spouse is asking for alimony is actually well off more, and is the man, rather is the woman, and she's well off. So what happened? So thank you very much. We certainly appreciate. And I think at this junction, we want to go to the Democratic Republic of Congo and want to introduce Monsieur Modeste Mulumba Mwamba. Modeste is an attorney, is an advocate in the DRC, is registered with Haute Katanga and Lualaba Bars Associations of more than 18 years practicing in different areas, including family law, patent. He's also a managing partner of the law firm, Modeste Mulumba Law Firm in Lubumbashi. I think that must be the second city in DRC. And he's a litigator by trade, and he belongs to a vast professional network, and is a member of East Africa Law Society, an African Lawyers Union, Commonwealth Lawyers Association, International Conference Bar Association, International Federation of Young Union Lawyers, International Advocates Union, and OHADA Space by Linking Network Africa in the world. So trust you me, we have the right person. Monsieur Modeste, vous êtes le bienvenu. Merci d'avoir accepté notre invitation. Bienvenue, karibu. Welcome to address us on what it is Bienvenue, bienvenue.
Asante, asante. Samuel,
Yeah.
I'm very
Yeah.
happy to be among you. And I will apologize, all of you, for my French intonation, because we are a French country and our official language is French. But like we are now a member of ELS, East Africa Law Society and East Africa Law Community, we have to make effort to speak and share our experience in English. They asked me to share an experience of practice and procedure of divorce and dissolution in DRC while sharing the new development and emerging trend in this area of practice. Like you present me, I'm a lawyer, and after my law practice, I'm also a teacher in Kalemi University. Kalemi University is in Tanganyika province, one of the 26 provinces of DRC. I will introduce my presentation by greeting all of you and thank the ELS for this opportunity. This communication have this plan. First of all, I will share with you the general notion of divorce in the DRC, the practice and the procedure of divorce and the dissolution in the DRC, the new development and emerging trends in this area, and I will conclude my presentation. In general, divorce is the legal termination of marriage, making the end of the marital union between two individuals, man and woman. It involves the dissolution of marital obligation and the division of marital assets and responsibilities. Divorce is usually the cancelling of the legal duties and responsibilities of marriage by dissolving the bonds of matrimony between a married couple under the rule of law of the particular country or state. This is meaning for asking the divorce in our country, you have to be legally married by presenting the marriage certificate. If not, you can't be accepted by our judge or our court in order to introduce your petition for a divorce. It can be said to a legal dissolution of marriage by a court or other competent body. From a legal perspective, divorce is a process of engaging partners from the legal marriage contract. It can occur through both contested and uncontested means, where contested divorce involves disputes over issues like child custody, spousal support, and division of assets, while uncontested divorce occur when both spouses agree on those terms and process with the dissolution amicably. On this part, I will say there's no way in our law to make divorce by consent. But like it's a contract, you can make it in doing something in the law firm, and you have to produce it to the judge in order to get the judgment, the decision, which pronounce the divorce. And the first thing to know about divorce is that it's a common and nothing to be ashamed of. However, it's important to note that divorce rates can vary significantly depending on factors like geographical location, socioeconomic status, and cultural norms. The main factors affecting divorce rates and trends is economic stability and employment opportunities, which can influence individuals' decision regarding marriage and divorce. In DRC, my country, the main reason of divorce is the irremediable destruction. That means the marriage has been broken by this irremediable destruction. And we can find this reason from articles 549 to 550 of DSC Family Code. Before concluding this part of introduction, we have decided to facilitate some legal words which will be used here. The key legal terms in divorce decoded. Like I've said in my introduction, divorce can be an emotional journey and a confusing legal process as well. And here, some key legal terms associated with divorce. Dissolution is legal termination of a marriage, also known as divorce, wherein spouse and their marital relationship and they become legally single individuals. Alimony, it's a spousal support, financial support paid by the one spouse, generally is the man or the husband, to the other during or after divorce processing, intended to provide financial assistance to the lower earning independent spouse. Custody is a legal authority and responsibility for the care, supervision, and decision-making regarding a child upbringing, including physical custody, where the child resides, and legal custody is the decision-making authority. Child support is a financial payment made by one parent to another for the financial support and care of their child or children, typically based on the state guidelines and calculated based on factors such as income, and the child's needs. Understanding those legal terms is essential for individuals navigating the divorce process, as they directly impact financial arrangement, living situations, and relationships with children. Seeking legal advice and support can help parties understand their rights and obligations and work toward fair and sustainable outcomes for all involvement. So we have to see practice and procedure of divorce and dissolution in the DRC. In the Democratic Republic of Congo, divorce have got some steps. First of all, you have to introduce the petition for a divorce. One spouse files a request for a divorce to the appropriate court, outlining to ground for divorce and requesting the solution of the marriage. The other spouse is served with the divorce papers, and he has the opportunity to respond, either contesting or consenting to the divorce. The second step is a conciliation. After introducing the petition for a divorce, the head of the court in our country is a peace tribunal. It's the first tribunal which is competent to solve the divorce cases. The president has to invite the spouse who are engaged in the conciliation to resolve issues such as child custody, visitation, division of assets, and spousal support. Conciliation involves a natural third party who helps facilitate communication and negotiation between the spouses to reach mutually acceptable agreements. On these steps, spouses are invited themselves without the counsels, and it can take from 6 to 12 months. Exceptionally, if the spouses doesn't live together for 3 years ago, this period can be reduced. After this step, we will have the case hearing and trial. If disputes remain unresolved, the divorce may proceed to the court, hearing, or trial, where a judge makes decision or contested issues such as child custody, support, and property division. After this step, it will be the finalization. Once also issues are resolved, either through negotiation, mediation, or court processing, the divorce is finalized. The court thesis is a final divorce decree. That means after the first level, the first degree to peace tribunal, you can have appeal to high tribunal or district tribunal. It's the same. High tribunal is the district tribunal. And the court issues a final divorce decree legally terminating the marriage and detailing the terms of the divorce settlement. However, every divorce process is different. For example, divorce law and procedure vary by the jurisdiction, including requirements for residency, grounds for divorce, and legal processes. Some courts may have waiting periods of mandatory counseling requirements before a divorce can be finalized. Furthermore, each divorce case is unique, with factors such as complexity of assets, the presence of children, and the level of conflict influencing the duration and outcome of the divorce process. Spouses may choose different dispute resolution methods, such as collaborative divorce or litigation, based on their specific needs and circumstances. And on this point, before speaking about new development, I have to say something about the dissolution of the marriage. In our country, we've got 3 ways to make a dissolution. The first way to make dissolution of the marriage is the death of one spouse. The second one is the divorce. And the third one is a new marriage. A new marriage. This new marriage can be done without divorce. Why? If one of the spouse is absent from 6 months ago, the spouse who is staying in the residence can go to the peace tribunal in order to get the judgment of the spouse who is absent, and to show that he needs or she needs to get in the new marriage. The new development emerging trend in this area of practice, according to the new development, we note that in the DRC, we've got an update or modification of the Congolese Family Code since the 15th July 2016. And in this update or modification, we've got the new terms of some law, some articles of our family code. And about the emerging trends in this area of practice, nowadays, most of divorce cases concern young spouses from 25 years to 50 years ago, and under 5 years of marriage, because especially of bad preparation or to get in wedding. And according this emerging trend, we can note also the homosexual problem, which is the actuality and has been prohibited in our country. And the last one, before concluding, it has been prohibited to marry a child, someone who is under 18 years ago. Someone who is under 18 years ago can't be married. And the problem of HIV in our country, we've got something, the law who is protected the HIV person. But those persons can be married in order if they have to give the information to their partners. If not, it can be another reason of divorce. So, but it's by this I will conclude. The final thing to know upfront about divorce is that the divorce is not the end of the world. Divorce is only crisis involving a very real end, but it is also a very real new beginning. It's also the end of a chapter of a life, but not the end of the life itself. In the midst of the divorce crisis are seeds of opportunities for making life into something again enjoyable, new, and creatively good. It's important to keep this hopeful and true message in mind as the process unfolds. Thank you for your attention. Asante. Merci beaucoup.
Monsieur, merci beaucoup. Merci. Thank you very much, Modeste. We certainly appreciate that presentation, that expose from DRC. I think there's something quite interesting to learn how it works in the DRC. And I think that one of the things that probably we have heard from you is something very an interesting and good innovation. I think we've also heard about this from Tanzania, the tribunals, they call it Peace Tribunal, promoting conciliation before spouses go to court as a mandatory requirement, and also having matters handled by those tribunals between 6 and 12 months, and before the parties can resort to the courts of law. And the requirement of mandatory counseling before divorce. Modest, there is something probably some people may ask you questions about it, quite interesting, about the ways in which marriage may be dissolved, the obvious one of death, but then divorce, but then there is the third one of a new marriage, where the spouse disappears for 6 months. I think quite scary, but I thank you so much. Merci beaucoup. Thank you very much. Thank you, thank you. So I think that at this point, we will defer the questions so that we can have the questions later on. Thank you very much. Thank you, Modest. Thank you, Council.
Thank you.
All right. We want now to move to our last presenter. We want to move to Rwanda. Aime Barushimana Kavuna, our colleague in Rwanda. Aime is a managing partner of Precious Law Chambers, and he presents legal solutions to his clients. He's also experienced in ADR, alternative dispute resolution. Aime is also a fellow of the Chartered Institute of Arbitrators, Kigali International Arbitration Center, African Association of Arbitration, and also is an international accredited mediator with the Center for Effective Dispute Resolution of London, Edwards Mediation Academy, accredited court annex mediator with the Supreme Court of Rwanda, and he's distinguished himself in practice for 18 years. He has been practicing in many fields, and you may want to know that actually he's one of the multilingual people that we have in East Africa, speaks French, English, and Kinyarwanda. Very much honored, extremely honored to have you, Aime. Urakoze neza. Welcome, bienvenue. Merci d'avoir accepté notre invitation. Bienvenue, messieurs. Welcome, welcome.
Merci beaucoup, Monsieur Samuel. Urakoze cyane. It's a Yeah, it's an honor for me to be part of this discussion. Though the last one in presenting, I'm not the least one. I do believe. If I can have my presentation on the screen, if possible. Can you share my screen? Is that possible?
Gabriel, can we have the screen?
Yeah, sure. Let me just have it projected shortly.
All right.
That will be helpful. I was saying I'm very happy to share this panel with my distinguished colleagues and share the perspective of divorce and dissolution of marriage in our lovely country of Rwanda. Is a peculiar country because we are like in a junction. We used to be a civil law country, speaking French country. That's what we used to be. Now we have integrated English. Of course, being a member of East Africa, we can even use Swahili and other languages. So we are privileged to have all these resources, and you will be enjoying my English. As my colleague Modeste was saying, myself, I've been speaking French for many years, but now I can do my best and present in English. And I know this will be also good. So Gabriel, please share if you can. I was trying on my end, but I was not successful. So, okay, Gabriel.
Gabriel, are we there? Are you able to get the technical team? Are we there? Gabriel?
We are almost there. I kindly request
okay.
that probably you start as I try to figure it out.
All right.
Okay,
Amen.
thank you. Let me start my presentation. Okay.
Are you able to see?
Yes, that's nice. Thank you. Dissolution and divorce and dissolution of marriages, practice and updates from the region, the case of Rwanda. Maybe we can get some generalities. Next, please. Okay, the Marriage Act in Rwanda is the law of 2016, which repealed a very formal law of 1888. So our law is somehow modern. It's the law governing persons and family. So through this Marriage Act, which is the person and family law, marriage is defined as a voluntary union of a man and a woman. That should be the other slide, preceding slide, please. Marriage in Rwanda is typically civil and monogamous. Yes, thank you. And differently from other jurisdictions that I've had, we have no Muslim, no Hindus. For us, marriage is civil. Even the civil, apart from civil marriage, no other union is accepted or recognized. Okay, next slide, please. Or maybe the preceding one. You can be back, please.
Okay. The next one. Okay.
The previous.
Well, the previous one. That one. That one.
Hello, can you hear me?
Yes, yes, I can hear you. Which page are we?
Yes, actually, I was at the second page.
Okay, sorry.
Yeah, I was at the second page, talking about generalities. So we can go to the, okay, even there. Marriage is defined as a voluntary union of a man and a woman in a monogamous and civil union. Other modes of marriage are ceremonial and not legal, like religious or any customary practice that some couple can choose. All that are not accepted and are not legal. Only civil marriage are accepted in Rwanda. Next, please. So I was about to talk about the marriageable age. The majority age in Rwanda is 18. Once you are 18 years, you have reached your majority. But for the marriage, the minimum legal age is 21. Anyone less than 21 is not allowed to get into marriage, but there is an exception. You can request what we call emancipation for particular reasons, like pregnancy and other reasons. So this can be granted as an exception. But by principle, for somebody to get married, you have to be 21. as I think in other East African region, sex marriages are not allowed. Only a man and a woman are considered to be worthy to get into a marriage union, because same-sex marriage is not recognized. It's considered to be against Rwandan culture, public order, and morality. Next, please. What is there provided by a constitution? The constitution provides the right to marry and found a family. This is under our constitution. And this civil marriage that is provided, as I was saying, has to be monogamous. It has to be between a man and a woman. And these spouses, maybe this will sound like different from other jurisdictions as I was following. Spouses, when they enter into marriage, they benefit for equal rights and obligation. Okay, we will touch on that again in the following slides. Next, please. I think we can talk now about the grounds of divorce. Our law, our family law is specific when it comes on the grounds of divorce, and we have 8 of them that we can find in this presentation. The first one is adultery. Second one, desertion for a period of at least 12 consecutive months. Conviction for an offense severely tainting the honor. You may recall that in our country we had like genocide, or people who are before court for serious offenses, their spouse are accepted to get that as a reason to divorce. We have the refusal to provide for the household needs, excess abuse, hearing this from other jurisdictions, gender-based violence, de facto separation for a period of at least 2 years, and non-cohabitation for more than 12 consecutive months from the day of celebration of marriage on unjustifiable grounds. You will notice that I've underlined adultery. Excuse me. You will notice that I've underlined an adultery and gender-based violence. These are the most reasons, the most grounds for which people go to court to request divorce. Let's go to the next slide, please. Okay, the action for divorce. Under Rwandan law, the action for divorce is only instituted by spouses. Action for divorce is instituted and judged according to the ordinary proceedings. This is the civil law procedure that we have in Rwanda. And an action for divorce expires after 5 years running from the time of discovering the cause of divorce. Let's say this divorce is requested due to adultery. When did you know about the fact that you are alleging before the court? This does not have to last beyond 5 years. If that's the case, your case will not be heard by the court. And in this situation, only spouses have the right to their action before the court. So it means that for divorce cases, there is no way of representation. Parties can only be assisted by their counsels in a divorce proceeding, but they can never be represented. Next, please. Okay. In Rwanda, apart from these 80 reasons, 80 grounds that I've presented, we have got a progress with our jurisprudence. The case law went to other reason, which is now qualified as divorce as a remedy. Remedy for a marriage that is untenable. I heard from other jurisdictions, this is not there, but in Rwanda, the failure of cohabitation between husband and wife the failure, if this failure is noticeable, it is a ground now of getting divorced due to the progress, the development of our jurisprudence. Yeah, this is one. On the other side, one of the spouses, if has lost affection, the fact of losing affection gives right to request for divorce. Of course, you will have to prove, you have to go into a gymnastic of giving real ground, but if it is established, the court can grant the divorce, though you are not falling under one of the 8 grounds that we have presented before. Next, please. Okay, I want to give some numbers. Maybe you will be astonished to find that in 2016, only 21 divorce cases were presented before the court. But from 2016 to 2017, the numbers went high, and they appear to be 1,311 cases in 2018. These numbers went growing. Last year, we had an excess of 3,322 applications. So you will find that every year, as we are proceeding, the number of cases before courts requesting for divorces are going crazy. Increasingly, the situation is there. And the statistics show that about 80% of divorce cases in our country are filed by women. Next, please. We are still talking about numbers. The rise of divorce can be attributed to modernity, a growing awareness of individual rights, a departure from traditional beliefs. In Rwanda, we have a say, particularly referring to women. You have to be patient, you have to accept, even if it's about suffering. We have this say of Niko Zubakwa. There's no other way. You have to remain there. You have to stick. But people slowly are going out of these beliefs, and easily they can seek for divorce in a way of escaping and fulfilling relationships. The other issue is the gender-based violence that seems to be prevalent in jurisdiction. And the other that I talked about is adultery, which is a gender-based violence and adultery. They are the basic reason for divorce in Rwanda. Next one, please. Okay. Now, let's talk about the procedures before court. The legislator in Rwanda tried to make this, difficult the process of requesting divorce, because the law procedure provides for 2 mandatory conciliation sessions before the judge in the primary court. So you have to go. Once you introduce your file to the court, you will undergo a first conciliation session with the judge. If this one fails, you will the judge will after 6 months he will introduce another session in which he will plead again for you to try to see if you can reconcile and go back together. And if this fails, then the case can go for pretrial and for the hearing. You understand that all this process can take between 12 and 15 months for you to get a final judgment on divorce. But basing on the principle that the marriage is the principle, divorce is an exception, the legislator put even the judge to let understand the couple to reconcile and go back together instead of running and getting the divorce. Next slide, please. Okay. Now, I heard that in almost all the jurisdiction, apart from DRC Congo, you don't have mutual consent divorce. We have this in Rwanda, and it is recorded under law. This is our Article 229 of the Persons and Family Law. It recognizes a mutual consent divorce, and by condition, this is has to be jointly applied request spouses. It has to be consent and sent both by both the spouses for the court to accept and entertain that request. This request cannot be applied by one spouse, and the other way, you cannot convert a divorce application into a mutual consent application. Next slide, please. But there is a condition for the mutual consent to be accepted by the court. For it to be accepted, the couple has to have lived together for at least 2 years. You should have at least 2 years of marriage before you, if you think you can request for the mutual consent divorce. Next. Okay, what about the custody of children? The custody of children is in general awarded to the spouse who obtains divorce. You remember that by the marriage that we have, all the spouses, they have equal rights. Since they have equal rights from the marriage, the spouse who obtains divorce is the one who gets the custody of children. The other spouse gets the right to visit them. He can talk with them, visit them, but the custody will be with the one who obtains the divorce. I can add here, if the children are under 6 years, there's an exception. Those children should be accepted to continue living with their mother, though she's not the one who gained the divorce. In a case, she's not the one who gained the divorce. She can continue keeping care of the child who are under 6. But in principle, the spouse who obtains the divorce is the one who gets the custody of the children. Next, please. Okay, how is marriage dissolved in Rwanda? As in other jurisdictions, as I heard, divorce is the first ground for dissolution. The second ground that we have by law is the death of one of the spouses, like in other jurisdictions. Okay, next, please. Okay, the effect of the death on marriage. Death of one of the spouses dissolves a marriage, as we saw. And the widowed spouse has the right to enter into a new marriage, ipso facto. However, the wife may enter into a new marriage after a period of 300 completed days from the death of his first husband. If we count, we found that this is around 300 days. This is around 6 months. So you cannot enter a new marriage, except, particularly for the wife, if these days did not elapse. But the right is there, but it's not automatic. You have to count these days and then envisage a second marriage. Okay, can we move to the others? Okay, children continue to be looked after by the surviving parent, even though she would enter into a new marriage. If she also dies or he also dies, they are supported in accordance with the law. They can become pupillage of the government, pupille de l'État, as we say it in French. So the government has the obligation to take care of those children once they have no other one to take care of in case of the death of both parents. But you understand we are in an African country. African people will not leave a child if the family can. They will take care of this child. But also the government can offer support and take care of that child. Next, please. Okay, what about the properties of the spouses? The death of one of the spouse give rise to the dissolution of the matrimonial regime and succession executed in accordance with relevant laws. In Rwanda, we have three matrimonial regimes. We have the regime of separation, fully separation. We have the acquired rights on the properties that you will get after the marriage. And the other one is the full community of properties. So we consider the matrimonial regime in order to decide on the dissolution. Okay, in case of dissolution of the community, spouses shall share common assets and liabilities. This is the principle, because there is no preference on one sex or the other, the husband or no, in Rwanda, we don't have this. In Rwanda, there are equality. So in case of dissolution of the community, spouses shall share common assets and liabilities. But the exception will be their matrimonial regime. Let's say they have chosen separation. If they have chosen separation of properties as their matrimonial regime, this will follow. But by principle, in case there is any need to do to dissolve, being by death, this will be a sharing of assets and liabilities on equal shares. Can I have the next? Okay. So now talking about the way forward, this eco-sharing has brought a lot of discussion, and there have been consideration that there are people who get into marriage targeting properties. So one of the new trends that is visible, the government now is discussing about an order that will push spouses to receive an equal share of assets and liabilities during divorce proceedings, because it has been noticed that very young couples now divorce. People can go for after 1 year of wedding and then decide for divorcing. So there is a trend to discourage that, and this is pushing legislators to think about how to establish an unequal share of assets and liabilities during the divorce. This is one way of curing what is noticed today. Next, talking about the other trend. The other trend is now we have a push on mediation and ADR in Rwanda. We have this court annexed mediation, which is taking place really that we didn't have before. And because of this, there is a move. There are discussion now on how to change the legal landscape and introduce into family matters the use of mediation, just to facilitate the processes, because believe me, we have many cases in court targeting divorces. So a way of dealing with this will be introducing family mediation and give even practitioners the way to practice and help couples who are struggling with their marriages get divorced through mediation. I don't know if this is the case in the region. Maybe Rwanda will be at the forefront, but this is among the new trend where we are going. On that note, I think I can thank you and say that I've been happy to participate and bring my contribution to this talk. Thank you so much, and God bless you.
All right, thank you. Thank you, Aimé. Que Dieu vous bénisse. Thank you very much. God bless
Merci
you.
beaucoup.
Je t'en prie. Now, I would like to thank you so much. Thank you for the Rwanda experience. That is quite interesting. And we've seen just a dichotomy, the lines that have been drawn in the way we practice our law. Maybe that is some of the areas that we will need to harmonize as East Africa, so that we have laws that are similar in our practice. I which is the civil marriage, the rest are ceremonial, and the ages are 21 years and above for you to be able to get into a marriage, creating absolute spouses. That is quite a development that there's a law relating. The law actually recognizes major gender-based violence and adultery as the major grounds upon which dissolution of marriage may be based. I noticed there is an interesting development in Rwanda, failure to provide for household needs. It's in Uganda, many people will get divorced if we can introduce that also here, and non-cohabitation for at least 12 months continuously. I think this is something. Another thing about Rwanda is that you don't allow marriage before the 300 days after the death of the departed spouse. And this is an interesting thing that I believe our audience has been interested in. So thank you very much, Aime Barushimana. Merci beaucoup. Urakoze cyane. Thank you very much. So at this very juncture, I wish to pass the microphone over to Gabriel so that we see if there are any questions for our panelists, so that you may be able to address them kindly. You can type the questions. Gabriel, you just come over so that you may let the participants know how they may channel their questions, either through the discussion forum or I don't know which other match.
Well, thank you so much, our dear moderator and our esteemed panelists. It's indeed been a very informative session. And well, I'll just quickly go into the chat section, and I can see a lot of appreciations from all our participants, thanking the different panelists for their very informative presentations. But interestingly so, I see a comment from Tabu Kumoy, who is saying that the discussion is very informative. He has personally learned a lot and is looking forward to learning more. But what is missing is Somalia, Burundi, and South Sudan. I think that is something that we will take into consideration and address in subsequent presentations. Members, the Q&A section is open, and I am already seeing questions streaming in. The first question that I see on my screen here is written by anonymous attendee, who is asking for any closing comment on the stance from the Kenyan courts that unregistered customary marriages are not marriages, that there is nothing to dissolve and parties cannot divorce. I think, Juliet, if you're there, you were looking at this question, and probably you'll be able to answer it. Juliet?
Yes. And
Yes.
and that's in my presentation, that there is no provision for registration of customary marriages. This was brought about by Gazette Notice in 2017. So now you can register. If you have not registered, you can't come to court and claim for dissolution. You can only come to claim for dissolution if you have had it registered. And there's provision for registration.
Okay, thank you, Juliet. I hope anonymous attendee is satisfied with that answer. But I still see a lot of appreciation coming in, and Natugonza Elizabeth is saying she has fallen in love with Rwanda's jurisprudence. I think particularly because of the provision that failure to provide could lead to dissolution of the marriage. Yes, but we do have another question coming in from Rachel Itenderezwe. I don't know if I'm pronouncing that rightly, but Rachel is sending her greetings, and she's sending a question to Mr. Mbarushimana, and she's asking what are your thoughts about the new trends in family law which allow a person under 18 to get married based on reasonable grounds affirmed by a civil status officer. Won't this cause other legal issues like corruption and alike? Over to you, Aime.
Thank you, Rachel, for this question. Myself, I'm curious to see how the legal framework will be, how will be the legal construction around this. Of course, it's still in plan. It's still it's a plan. We have not yet seen that. Since this could be allowed, what will be the situation? How will the legislator organize so that this serious thing can be under the hands of these civil status officers? So, I was saying that the legal marriage is 21. And today, for you to get an exception, if you are, let's say, 19 or 18, for you to get married, you have to get a special authorization through the Minister of Justice, which is a thorough process. You have to prove, you have to give grounds. So how will this be accommodated by our administrative local authorities? I don't know. I'm real curious myself, and maybe time will judge that, and we'll see what will come out from our legislators. This is what I can say at this.
Thank you, Aime. And while you're still at that, I see another question that has been shot at you by Benjamin, and Benjamin is asking, in the case of Rwanda, does death cause dissolution? Does the death dissolute the matrimonial regime automatically in Rwanda?
Of course, there is dissolution, and it means the surviving spouse become single. If everything that goes with the right, everything that goes with the right and the obligations is dissolved. So the individual becomes single. This is the right way of bringing this and explaining. Thank you.
Okay, and then the third one, I see a lot of questions coming for you, Aime. So just be on your toes. There's another question from Miss Ingabire, and she's asking what happens if judges in court refuse to grant divorce to parties due to lack of evidence. Hello, Aime, are you there?
Okay, what happens if judges in court refuse to grant divorce to parties due to lack of evidence? Okay, I'll say, like, we know when you fail to prove your case, you fail. So nothing to say. Once you can't prove, there is no gain.
It is what it is.
There's nothing to gain. Yeah.
And then there is another question before we...
Maybe a short comment on this. Maybe a short comment. Divorce cases are the most documented cases, because you have these 2 sessions of conciliation, and everything is the court process is always in camera. So you have the liberty to talk, but most of the time, you know, spouses, they know the weaknesses of each other. It can be, the discussion can turn around, let's say, property. A wife can say this, I know we have a house in this corner of the country, but I can't find the document. So we have a house, we have to share that house. But if you fail to prove that house, you fail to prove using the documents, using the legal way of proving, of course you will lose, though what you are saying is right. Yeah, this is a thing that is normal in court, so I have no other way to explain it. Thank you.
All right, thank you. Now, there is another question that has been persistent. Yes, Juliet.
I have a matter like that, but it's still on appeal. I think when it gets, I'll share here. When my case went to court, petition for divorce, and the magistrate actually refused to grant the divorce on grounds that it will take a toll on the children. Of course, she says that the magistrate was seen behind doors, behind closed doors. I don't know how true that is, but it's true. She was not granted a divorce. So we have appealed, and we are waiting to see what happens.
Yeah,
when it's resolved, share it here.
All right, thank you, Juliet. And while you're still at it, there's a question from my senior, Mr. Ochil Dudley. I salute you from wherever you are. Mr. Ochil is asking you, registration is not an element of customary marriage, and he's rather clarifying that registration is not an element of customary marriage. A customary marriage is informal and purely governed by custom. How would its validity be tied to registration, an element foreign to customs and customary marriages? Do you wish to respond to that?
I stand guided, and now that he's your senior, I should believe that he's also my senior. But perhaps he would also help throw light. So how do customary marriages get dissolved? And then in light of the provision that customary marriages can be registered, what is the effect of registration? Is it just for purposes of registration that is registered, or what is the effect of the registration?
Thank you. We still have lots of questions coming in. Ms. Ngavire is also okay, so we just have a lot. There's one from Sadat going to you, Aime, and Sadat is saying, according to Rwanda statistics on divorce and the government's efforts to break the high figure of divorce, do you think that polygamous marriage could be another way to solve this crucial problem?
I don't believe directly I give my answer. I don't believe, because we still have adultery as a crime. So accepting polygamy, you should first change that, because by principle, by constitution, the marriage is monogamous, and this takes away people for fornication and other practices. So the thing that we can talk about here mostly is not going on only on the side of polygamy or having one wife or having many. No, there is an issue of modernity. The increase of let's say feminism, you know, these liberties and rights, and sometimes people don't understand these new concepts that come with modernity, and maybe due to equality of the spouses, which is key in our constitution, The wife sometimes does not know her limits. The husband does not know his limits. And the fact that people can get money now, getting money now seems to be easy like before. And sometimes even the wife can get a lot of properties than his husband. So sometimes this think of respect and you understand. So we're Africans. We still have this conflict of traditional beliefs and the modernity that we have. Okay, maybe on, I don't know on which level allowing polygamy can cure this, but I think still we are navigating into this modernity thing. We will still have these cases going higher since finances are there, and you know money is the key, and sometimes for a higher rate this is the problem. Thank you.
All right, thank you so much, Aime. I will now take it back to Mr. Ejoku. We've run an hour more than what we had planned. So
Okay.
I'll send it
Okay.
over to make the concluding remarks. Thank you.
All right. Thank you. Thank you, Gabi. Thank you, Council Gabi, for arranging this this engagement. I believe it has been quite engaging. Unless for our guests, if those who are still there, they can say their goodbyes in 10 seconds before we go away. I see Emma is still there, Juliet is still there. I hope Modeste is still around, and then Dr. Harriet, then please, let's go one by one. Just anything you'd like to communicate to the community. We can start with Amen, just in 10 seconds before we call this quits. Okay, anyone?
Thank you very much. Thank you very much, Samuel. Thank you very much, East African Law Society, for giving us, giving me a chance to be able to present the Ugandan situation. And from all the presentations, I can see there's something unique about each country. And I hope we'll be able to learn from each other. And for Uganda, as we are trying to amend our very, very old law, we hope we'll be able to pick a leaf from each of the countries, and we can be able to put it in our law. I thank my colleagues, the panelists, for their presentation, and I hope we can be able to work together, and we see how we can help the people continue to remain married, but then also when things can't work well, then how we can help them to have a civilized way of divorcing, and they continue being friends. Thank you very much, and have a happy, a wonderful evening for everybody.
Thank you, Dr. Diana. Dr. Baraka, are you still there? Okay.
Dr. Baraka has a class, so he has to...
Oh, he left. Okay. Okay. Juliet? Madam Juliet Komagum?
Yes, I'm here, and my parting shot is that I would like to encourage practitioners. Let's try mediation. It works. Sometimes when people come to you as an advocate in the heat of the moment, they're very angry. But when you give them some time to think about it, you never know. They could come down, give each other something. After they've left each other, they might think about it. But if you're in a rush to run to court, they have the certificate. Remember, divorce is an emotional, it's an emotional pattern. So the divorce paper does not address the emotional pain that the parties might be going through. But if you try mediation, you never know. To give the parties time to heal, they could just think about it, so that at the end of the day, you have a divorce. You don't have a very bitter divorce, especially when there are children involved. Many times I see advocates who are very quick to rush to court and get better. Then 2 years later, your client is still calling. They are still hurting. Let's give mediation a chance. Let's handle them with some soft gloves. Thank you. That's
Right.
all.
Thank you. Thank you, Council Juliet. Asante sana. Shukran. Um, Mr. Modeste Mulumba Mwamba, Monsieur.
Yes, Samuel.
Yes,
I'm on.
please.
It was very happy for me to share a Congolese experience on divorce and dissolution of the marriage on our area practice. What I can say, I've learned many things here because in Congo we are using civil law, and all of the countries around Uganda, Tanzania, Rwanda, and others, which are in ELS or East African Community, are using common law. And it was very important for me to share this experience with all of panelists, and I learned more. That's why I need to wish you an happy evening, and all of the followers to stay well and pass well their weekend, because tomorrow it's the beginning.
Thank you.
Many
Thank
thanks.
you. Thank you very much. Greet our brothers and sisters in DRC. Les saluer beaucoup. We love them. We hope to meet you again, Modeste. Amen.
Many thanks.
You're welcome. Modeste, c'est votre opportunité maintenant.
Okay. Thank you.
Oui. Amen. Vous êtes
Yes.
là?
Oui, je suis là. Merci, Samuel. Thank you. Thank you for this opportunity to talk, to share the panel with other eminent colleagues. And I think this has been my first time to do this. And other opportunities will follow, I believe. I cannot leave this without saying something about what I'm seeing on the chat. There are some colleagues who are here arguing that for them, polygamy should be a solution for divorce. I can see Mispa that I know. I can see Sadat. Actually, what I can say, I don't think that polygamy can strictly be considered as a solution for the rise of divorce that we are facing now. Why am I saying this? Though I don't have the last statistics being in the region and even in other countries, we heard from Tanzania, from Kenya, from Uganda, where you have this right for polygamy, even from the religion and even from the traditional marriage that is accepted. People are married and are polygamous, but yet they do divorce. So what should you say about such a situation? This means that polygamy by itself cannot cure the rise of divorce that we are seeing today. Maybe we can find solutions which will not be one way, maybe different ways to cure this. And I really encourage that we take care of the rise of modernity that we have dealing with private law. So there is a concern, the stability of rights of people and their obligations towards the trend of modernity and technology and whatever that we are seeing now. Maybe research on that way will help us understand a lot. But we are still here, even rise of divorce in polygamous societies. So religion is not the cure. For me, polygamy is not the cure. So there are different aspects that should be considered, and this will help our society get stable marriages and strong families. So I thank you, and asante sana kwa yote.
Asante kushukuru. Asante kushukuru. Thank you to our panelists. We have very much been honored to have you eternally, and we believe that we shall continue to have a lot of interaction with you. Greet our brethren in DRC, in Kenya, in Rwanda, and, and all those in Burundi. And we believe that we will be having Somalia and South Sudan, and the next time, hopefully, when we organize the next engagement. Thank you, East Africa Law Society. Thank you, Gabi, and your very great team that has been working in our background, the IT, the technical team that is ensuring connecting all of East Africa so that we may have this engagement. Thank you, colleagues, brothers and sisters. May the Lord bless you. Have a wonderful time. Wishing you the very best in your practice. And goodbye.
Thank you. Goodbye. Thank you, panelists. We are grateful. Have a blessed evening.
Thank you.